Good afternoon. I'm Catherine Saldana, one of two mentor attorneys with the Dallas Volunteer Attorney Program. Thank you for attending today's Termination and Adoption Basics CLE. As many of you know, the Dallas Volunteer Attorney Program is a joint project with Legal Aid of Northwest Texas and the Dallas Bar Association. We have several intake clinics monthly, some are virtual, some are in person, and of course we have financial eligibility guidelines that we must follow. Most of our cases are family law, mostly divorces. Most of our clients are women. And so this area of law, family law, is different from other areas because it means more to our people than any other type. This is their lives, their children, their families. We are fortunate today to have Jenny Womack as our speaker today. She is a 1991 graduate of the University of Texas in Austin, where she received her Bachelor's of Arts with high honors in economics. In 1998, she also received her Juris Doctor with honors from the University of Texas at Austin. In addition to her law degree, she is trained in mediation, family law, mediation, and collaborative law. She has helped hundreds of clients seeking to build their families through adoption, surrogacy, and all manner of assisted reproduction matters. She's handled all types of family law cases, but her current practice is focused exclusively on family formation law. As a young lawyer, she was an active member of the Dallas Young Lawyers Association, serving as on the board of the DAYL as well as the board of the DAYL Foundation, of which she is a life founding fellow. In 2009, she was selected as an angel in adoption by the Congressional Coalition for Adoption Institute, and in 2013, she helped launch the Texas chapter of the Gift of Adoption Fund, a nonprofit organization that provides grants to families who are seeking to adopt. She currently, the most important part, serves as president of the Academy of Adoption and Assisted Reproduction Attorneys, an international group of attorneys to which she was admitted as a fellow in 2004. Thank you, Jenny, for being here today, and I'll let you do your presentation.
Thank you, Catherine. Okay, so unfortunately, I did not get to test this, so we're hoping my share screen works. So let me pull this up and hope that we're able to get this to work properly. Okay, come on. Here we go. It looks like it's working. So today we are here to talk about termination and adoption. And basically, we're going to talk about the basics. The adoption statutes are state specific, so they are covered in our family code. These are the relevant chapters. 162 is adoption, 161 is termination. The other ones that come in a lot are going to be 152, 102, and 107. And we'll touch a little bit on those as we go. The adoption process in Texas is essentially two steps. The first step is terminating parental rights, and the second step is the final adoption. Now, since the child is supposed to be in the home with the adoptive parents for a minimum of 6 months before completing adoption, I usually do these as two separate cases. Most of the cases I do are newborns, but it can be done together if you've got a situation like step parent or other relative adoptions where they've had the child for a long time, or a lot of my what I call second parent adoptions. I do those. A lot of times those don't even need a termination, but if they do, I do combine those as well. One of the first issues, just as in any case, is going to be your jurisdiction. Personal jurisdiction, of course, you know, can be waived. It's not fatal if it's lacking, but subject matter jurisdiction is a little different because, of course, it can't be waived. And any order you get that when the court does not have subject matter jurisdiction is invalid. It is void. It is no good. So you want to make sure that you do have your subject matter jurisdiction. Again, most of my cases tend to be newborns, so that are born in Texas. So subject matter jurisdiction is pretty straightforward. But when I do have older children, I always have to check, is there a previous court? Was there a court of continuing jurisdiction? Was there a divorce or some kind of child custody case previously about the child? And if not, then I look to what's the home state of the child. So if it's a situation where it's relative adoption, older child, but the child has only been in Texas for 2 months, there might be a home state elsewhere we got to worry about. UCCJEA does apply to terminations. It doesn't apply to the adoption, but it does apply to terminations. So you want to make sure if you've got that court of continuing jurisdiction and you're doing termination, you're looking at going back there or finding a way that you don't have to. Standing, pretty straightforward. This is going to be in Family Code 102. You've got the department or CPS, any licensed child placing agency, someone designated in an unrevoked relinquishment. Most of my cases are either agencies or unrevoked relinquishments, or you've got that step parent, second parent. Occasionally I do end up in some of these other qualifiers, but those are my less common, the latter three. Interstate compact. So if everybody's in Texas and has been in Texas, you don't have to worry about interstate compact. But if a child is going to be crossing state lines for the purpose of adoption, and in fact, if they've already crossed state lines for the purpose of adoption, you need to comply with interstate compact unless you fall within the limited exceptions, which are step parents, grandparents, aunt and uncle of the child. So not a great aunt and uncle, but an aunt or uncle of the child are exceptions to ICPC. If the child came from another state, not for the purpose of adoption, and was in Texas before adoption became an issue, that also would not apply. But if the child is coming from another state, even if they're already here, but they were maybe brought here for an adoption, you need to comply with ICPC, and doing that retroactively can be problematic. I do recommend that you confer with an attorney in the other state that's involved as early as possible to make sure you know what that state requires. There is a regulation 12, that all of the states work off of, but some states do require more. Illinois, New York, some of those states do require more. So I do highly recommend you talk to an attorney in another state. And a good way to find another attorney in the other state is to go to the Academy of Adoption and Assisted Reproduction Attorneys website and do the find an attorney search by state, see if you can find an attorney in the right area. That website is right there for you. You do have to file an affidavit on every termination and adoption suit stating that either you've complied and obtained approval, or that you didn't comply because it didn't apply or what have you. A couple of things to be aware of when you are getting consulted on adoptions kind of up front is if the child is not a US citizen, even if they're in the United States, and even if they are, here, whether they're under a visa that's expired or under a visa that is still current, if they're not a US citizen or legal permanent resident, you are probably looking at an international adoption. And that has a lot of extra hoops that are beyond the scope of today's talk. But if that happens, just beware that is probably an international adoption. At a minimum, you're going to want to bring in an immigration attorney to make sure you don't do something to jeopardize immigration if the goal, or at least one of the goals of the adoption, is to include citizenship. Another thing to be aware of are secondary placements. So when you're talking about a little bit older child who's previously been adopted and they're now wanting to, you sometimes hear it called disrupted. The adoption's been completed. That's not really an appropriate term, but if they're wanting to sort of undo the adoption, let someone else adopt the child. Most of the cases that I've dealt with on this were international adoptions where the child got here and had more issues than the family expected, and they needed to find a new family that could handle the child's needs better. But there are some restrictions and there are potential criminal penalties if you do not handle those properly. That child cannot change from the current parents to the new prospective adoptive parents until you've gone through the appropriate processes. And that's either going to be getting a court order, or if it's an ICPC case, getting ICPC approval before the child even comes into the custody of the new family. And then, of course, another thing to be aware of is that you can't provide financial assistance in an adoption unless it's through a licensed child placing agency. Otherwise, it's a felony. The only exceptions are to pay legal, medical, or counseling relating to the pregnancy and adoption plan. So if she's got insurance and has copays, they can pay the copays for the medical. They can pay for prenatal vitamins. They can't pay for maternity clothes. They can't help with groceries, gas money, rent, cell phone, none of that. They do any of that, it's a felony, unless they've gone through a licensed child placing agency. So let's get into a little bit more than nitty gritty. So step one is the termination of parental rights. You can do this, of course, voluntarily or involuntarily. So we're going to start with voluntary. When you're doing it voluntary, this is going to be with the birth mom. She's going to sign an affidavit of relinquishment. This can't be signed until at least 48 hours after birth. The contents are outlined in the family code. If it is a licensed child placing agency, or if it is the department, it'll likely be irrevocable from when she signs it. It does have to state that. But with licensed agencies or the department, it can be irrevocable. If it is a private direct placement to the adoptive family, it can't be irrevocable. It's either going to have a 10-day revocation period, or the statute does provide that you can do a 60-day irrevocable period. I don't recommend using that anymore because for the most part, terminations are not getting done within that 60-day time frame, and therefore it's now revocable. So it's leaving open some risks. So I always do on my private direct placements, I do the 10-day revocable, becomes irrevocable on day 11. You have to have 2 witnesses and a notary. And you can't have any conditions. So post-termination contact, things like that cannot be included in that relinquishment. The other thing you need to be aware of is the Indian Child Welfare Act. If there is a reason to believe the Indian Child Welfare Act applies, you would then have to go through, even doing voluntary placement, you have to do ICWA compliant consents in open court, and those have very different requirements to our typical affidavit of relinquishment. Now, this may become moot. There is a court case up in front of SCOTUS right now that's got oral arguments set for next week. And depending on what that opinion comes out saying, that could all change. So I'm not going to get into a lot of detail on that because we don't know what's going to happen there. Now, when you get to the fathers, there's, of course, a couple different types of fathers from a legal standpoint. You've got your presumed or acknowledged father. Presumed is that husband or divorced within 300 days of the birth. Acknowledged is what I call when they've signed an acknowledgement of paternity about the child. Often, if they're going to put acknowledged dad on a birth certificate, the hospitals will make them do an acknowledgement of paternity. So if they're a presumed or an acknowledged father, they also sign an affidavit of relinquishment. Same requirements as birth mom. So 48 hours after birth, same contents, all of that kind of thing. Even if the presumed, or conceivably you could have an acknowledged father who's not biological, there's some issues there, but we won't cover. But even if they're not the biological father, you have to terminate presumed or acknowledged father. And ideally, that's voluntarily being done with the affidavit of relinquishment. Now, if you've got an alleged father, which is basically any father who's not presumed or acknowledged or adjudicated by a court, that would fall under the presumed and acknowledged. He can sign an affidavit of waiver of interest. That can be signed pre-birth. The contents and formalities are pretty similar, but not identical. So those are laid out in the code. It does not have to include an admission of paternity. And in fact, I have had cases where I put in specifically that while he understands he's been named by the mother as a possible father, he doesn't believe he is, or he denies that he is the father. It is irrevocable from signing, even with those private direct placements. So there's another difference from the relinquishment. It also cannot be used by anybody to establish his paternity. So the mother can't come back later and say, look, you signed this waiver. That means you think you're the dad. She can't use it against him. The one caution I make is, again, if you're dealing with a situation where the mom and dad are together, or if not together, are still working together, and he may want to be on the birth certificate, if you're looking at this pre-birth, you want to make sure if he signs a waiver of interest that he doesn't do an acknowledgement of paternity at the hospital. Because if he does an acknowledgement of paternity at the hospital after the baby is born to get on the birth certificate, your waiver of interest is no good. You can't use a pre-birth waiver of interest. You need to go back and do the affidavit of relinquishment. I have had that happen to me once, so I'm very careful about that now. So if you aren't able to voluntarily terminate, you've also got options to involuntarily terminate. There is a long list of grounds in the family code, and this references an exhibit that I'm sorry you don't actually have, but they are all listed under 161.001, and that's your abandonment, neglect, so on and so forth grounds. With an alleged father, there's also 161.002, which references our paternity registry. And so if you've got a child under the age of 1, you can actually terminate an alleged father for failing to register with the paternity registry without notice. Now, I will caution that if you name him in your pleadings, there is some conflicting case law about whether you have to serve him. There's a case out of Houston that says you do. I think there's a case out of, I can't remember if it's Dallas or Fort Worth, but somewhere up here in North Texas that says you don't. So what I do is in those scenarios with an alleged father who is not signing a relinquishment and I want to use paternity registry, I don't name him. I throw him in with my unknowns, unnamed or unidentified fathers, because I do terminate potential unknown, unnamed, and unidentified fathers using our paternity registry in every case that I don't have DNA telling me who dad is or a court order telling me who dad is. If you've got a child age 1 or older, then before you can rely on paternity registry, you have to do due diligence to identify, locate, and serve. And of course, if they file with the registry, then of course you do have to serve them and move forward. As with voluntary termination, any termination really, you have to prove clear and convincing evidence, and you have to prove child's best interest. In your petition to terminate, you file a petition whether you're voluntary or involuntary. I include all possible grounds. So for example, I have birth mom who has signed a relinquishment, but she has also voluntarily left the child alone in the possession of another, not the parent, and expressed an intent not to return. Most of my cases, that's the case. They're agency situations, and they've left the child with the agency and prospective adoptive parents and said, we want you to adopt, we're not coming back. So I include both of those grounds. If you have other grounds, baby's born addicted, if there's abuse, if there's been neglect, that tends to happen more often again on older children, not my newborn cases, but sometimes. You need to allege your best interest. I attach most of my documents as exhibits. So my relinquishments, waivers, anything I have when I file my petition, I will attach as exhibits, in part because I do file pretty much always in Dallas County. And once you file your petition in Dallas County, you can't e-file anything else into the case. Everything else you have to hand file. You can mail it in or take it in by hand, but you can't e-file it any further. It gets sealed. That's not true in every county, but it is in Dallas County. The caption on your petition should just have the children's initials and should have that sensitive data notice. Y'all should be familiar with that. And again, I am normally filing after relinquishments have been signed. It is possible to sign prior to relinquishments if you have standing. So with the department, adoption agencies, yes. With direct private placement, they may not have standing unless you've done like a statement to confer standing or something. But I usually wait and file after the mother has signed a relinquishment at a minimum. Serving a parent. So of course, involuntary termination, other than that alleged father circumstances where you might be able to rely on paternity registry, you might not have to serve there, but you do have to serve a husband who doesn't sign, or an acknowledged father who doesn't sign, or if you've got a case where you're going after mom for step-parent adoption and she won't sign, you've got to serve her. You do remember that you can do, if you have problems with that, you've got your citation by publication or alternative service. I recently had to do an alternative service where we served on the mother's mother. Make sure, you know, in order to do that, of course, you've got to have your court order, you got to do your due diligence, file your affidavit, all of that. If you're doing citation by publication, you need to also be sure you get posted on that public information internet website. which fortunately I've only had to do once or twice because that can get a little complicated. The clerk's office does that for you, but you need to make sure it gets done. You are required to file the adoption evaluation, formerly known as a home study. You do need to file that in termination suits when you're talking about private direct placement cases. You don't in CPS cases doing termination, which y'all would not be working on, or if you're working for an adoption agency, which again is a lot of my cases, I don't have to file the adoption evaluation in the termination, but you do have to file it in every adoption. That does include step parents. The statute says shall. It's not, there's no provision for waiving it. I know people are saying that some judges are doing that in places. There's no provision to waive that. I can contrast it with our gestational surrogacy law that does have a provision to waive the home study. There is no provision to waive it. So you need to have a home study. And frankly, as an attorney, I think it's safer for you if you've got a home study, because if something goes wrong and you didn't have a home study, I don't know for sure what liability there could be there, but I know if I'm amicus or ad litem for a child, I want to see that study. I don't want that on my head. You can get the court to order that qualified evaluator, or you can use family court services. I know with the DVAP cases, I think it usually is using family court services, and you will need to get the court to order that. So it'll get done after your petition is filed. You generally would have pre-placement and post-placement, but again, a lot of the DVAP cases I know are slightly older children. They're not usually newborns. They are usually more relative or maybe fictive kin placements. So the child may already be in the home. So it may not be a separate pre-placement and post-placement. But if you're doing them outside of DVAP, doing them privately, things like that, there should be, a lot of times there's going to be pre-placement and post-placement. Trial or prove up. Of course, if it's uncontested, you just do your simple prove up. Make sure you've got your amicus, any ad items, all of that involved. If you're doing your defaults, be sure you've got your service members affidavit. If it's after publication, that statement of evidence that you need as well. If you're doing contested, it can be either a bench trial or a jury trial. A lot of my out-of-state colleagues can't believe that you can do a jury trial for terminations. And then I remind them, I'm in Texas, you can do a jury trial for pretty much everything. You can get preferential settings upon request. That's not usually a big problem in Dallas County because most of the time, unless you've got a court of continuing jurisdiction, you're going to be over at the juvenile courthouse where basically everything over there is preferential. But if you are in a county with a more general docket, you should be able to request preferential setting under the code. And of course, make sure you're always proving up your best interest. But a prove up, that can be real simple and just say, based on information, you believe it's in the best interest of the child. It's a trial. Obviously, you need to go through those factors that are in the Holly v. Adams and all of that. So the termination order. I just want to check my time because I don't know how fast I'm going, but I'm trying to go fast. Termination order. A minor child retains the right to inherit through biological parents unless that order says otherwise. So if you don't want that to happen, you need to make sure that your termination order does cut off inheritance rights. You need to have a finding in your order about continuing jurisdiction. A lot of times you can say you've searched the Bureau of Vital Statistics and there is no court of continuing jurisdiction, or you can say no search is required because there was no contest to the claim that there's no continuing jurisdiction, court of continuing jurisdiction, or you're in the court of continuing jurisdiction. Your order is going to appoint a permanent managing conservator, unless of course you're combining the adoption in one proceeding. I recommend you go ahead and specify the rights in your order and not just reference the family code section, and specifically include the right to consent to adoption if, of course, you are not combining the adoption. You do not have to send the birth parents a copy. There is a 30-day appeal period. If you've done voluntary relinquishment or waiver of interest, they can't attack it after 6 months, period. And even within that 6 months, they would have to show fraud, coercion, or duress. And sealing the record, your order can always include that. Dallas County will seal the record whether you ask for it or not. I usually do ask, but it will get sealed whether you ask for it or not. It's automatic in all Dallas County terminations and adoptions. In terminations, and I'm focusing here again, not on cases involving CPS and the department. If it's a private agency or if it's a direct placement. Amicus attorney, you have an amicus attorney instead of an ad litem for the child. Their duties are very similar to an attorney ad litem, including that they're required to interview a child who's 4 or older. But they're more like a guardian ad litem in that they're not bound by expressed objectives. It is a discretionary appointment when the department's not involved. But I will tell you, in Dallas County, most of the time, well, over at the juvenile courthouse, they will always appoint them in termination cases. If you're over at George Allen, it depends on the judge and the facts. If you're doing anything involuntary, odds are you're going to have it appointed. Some judges will do it even if it's voluntary, but there's kind of a mix. So you do need to check with your judge if you don't already know, since it's discretionary. But I will tell you, if you are over at the juvenile in the 304th or 305th, every termination case, you need to get an amicus appointed, whether it's a private agency or a private direct placement. Guardian ad litem or AAL, attorney ad litem, again, these are only, guardian ad litem only in department cases. That's mandatory. If they're an attorney, they also serve as the AAL as in a dual role. They have different focuses. And if there is a conflict between best interest and the child's objectives, any attorney in the dual role has to seek a separate attorney, guardian ad litem, because the attorney ad litem does have to focus on the child's express objectives. Attorney ad litem for parents. So if you've got an indigent parent, it is mandatory in department cases, discretionary in private agency or private direct placement. It then kind of depends a little bit on the judge. If they come in asking for it and they can prove they're indigent, odds are judge may appoint one. And in that case, the county does not pay for it if it's not a department TDFPS case. You do have to have an attorney ad litem appointed if you're serving by publication or other alternative service. The court may appoint one for an alleged father that you're terminating for not filing with attorney registry. I've never had that happen in any of my private cases. It is mandatory in certain CPS department cases. If you are serving in that role, you need to make sure you're checking on the due diligence. If you're doing it for, a parent that was served by alternative sources, whether publication or what have you. If you're representing an alleged father in that scenario, you want to make sure you check the paternity registry certificate, all of that kind of thing. The next step, and I know that there are questions, I will try to come back to those at the end, just to make sure we get through everything. The next step, of course, once you've got your termination, is final adoption. As we talked about, can be combined with the termination suit, but that's not, again, always prudent. If the child hadn't been in the home long enough, you probably want to do your termination suit and get it done, and then wait and do your final adoption once the child's been in the home long enough. Statute does say 6 months. Also does say it can be waived for good cause. That's pretty, it's not unusual to waive a couple weeks off the end, but if you're trying to do it after 2 or 3 months, you need to have a really compelling reason. For example, I had clients that worked for the State Department, were about to be stationed overseas and couldn't get the orders to include the new baby unless the adoption was completed. And so the court did allow us to finalize after 3 months in that scenario. If it's an adoption from an agency, agencies have to do post-placement, 5 post-placement visits over a period of 6 months. So you're not usually going to be able to do it sooner than that. The agency is not going to consent. Again, we talked about that the UCCJEA does not technically apply to adoptions. So if you're filing it separately from the termination, you can either go back to where the termination was done, or you can go to the county where the child or petitioners reside. There is a specific provision in the code that allows for that. So for example, if I've done the TPR in Dallas and the family lives elsewhere in the state, if they want to come back to Dallas, great, we can do it in that same court. If they want to do it in Harris County where they live, they can do it in Harris County where they live. Some of the prerequisites for adoption, if the petitioner is married, the spouse must join in the adoption. That does mean, of course, you also have to have both spouses approved for the adoption in the home study. I unfortunately had that case crop up one time where a spouse was much older and the home study could not approve him for adopting a newborn. So they weren't able to do an adoption. If your petitioner is not the managing conservator, so again, this would be in scenarios like if they're adopting from the department, or if they are adopting from an agency, or maybe even if the child is being placed by a relative who has managing conservatorship under a previous termination, but doesn't want to adopt. You need written consent of the managing conservator. In step parent cases, the assumption would be one of those petitioners is a parent who's a managing conservator. So you don't need to have written consent of both managing conservators in that scenario. If the child is age 12 or older, they also have to consent either in writing or in open court. Because so many of my prove-ups nowadays are being done by video, I am having them do it in writing. And then also having them testify during the court hearing, but I do it in writing as well. And they should appear, both petitioners and child should appear in court unless it is waived. And if the child is 12 or older, it is required unless it's waived. So for the child, that would be best interest. For a petitioner, if it's unduly difficult. Back in the day when they had to come back, might have to travel back for my interstate cases. And they might have to travel back to do the hearing as opposed to doing it by video. I could often get it waived so that just one petitioner would come back and other petitioner can stay home with the baby so that they weren't having to travel with the baby. Required documents in the adoption. So we've already talked about the ICPC affidavit. I don't think I mentioned the UCCJEA affidavit. You would have to file that in termination as well if you have a party from out of state. Termination order, if you're doing separate actions, you need to file a termination order. Or, for example, if you're doing a step parent adoption where the other parent's deceased, I filed the death certificate as proof of that parent's deceased. You need your adoption evaluation pre and post, assuming you have both. You need your health, social, education, genetic history report. You don't need that if it's a step parent, grandparent, aunt, uncle, adult sibling. Criminal clearances on the adoptive parents dated within 12 months. So sometimes the clearances for your home study or your adoption evaluation pre-placement might be more than 12 months old. You need to make sure you update those. And of course, we talked about the consent of managing conservator and child already. Your order. So your order does need to include findings of all the different requirements. I am very specific and say, you know, this has been filed, this has been filed, this has been filed, this has been filed. You do have to, of course, state best that the child adoption's in the best interest of the child. If you are combining your termination and your adoption together, your decree, your order can be an order that includes both pieces. I basically do the termination first. I have a statement on best interest for the termination. Then I put my adoption findings and best interest for the adoption. You need to have separate statements on that. You can put them in the same paragraph if you want and say terminations in the best interest, period, adoptions in the best interest, period. But you need to have separate findings of best interest for each piece. You can also, of course, include a name change for the child. This is pretty common in adoption. But if for some reason I'm working on a step parent adoption now where it's dad and stepmom, kids' names aren't going to change. In that scenario, in my court order, I just include a line confirming that their names are remaining the same. That way it's very clear I didn't forget a name change. And again, you can seal the record, but of course, Dallas County will seal the record for you. Amending the birth certificate. So the certificate of adoption form, it's VS 160. You can get it from Vital Statistics website. They have a new version that came out, I think, in March, and it will combine the certificate of adoption and the birth certificate application form. So you no longer have to do two different forms if you're familiar with that from before, all in one form. You, if the child was born in Texas, then what you're going to do is you get that certificate of adoption certified when you get your certified copies of the adoption decree, and you're going to mail that certificate with the photocopy of the ID of the parent who signed it. Or you can now do it as the attorney. It does specifically provide for that. I don't. I still have my clients sign it because that way they've looked at it and verified the information is correct. But you send in a copy of their photo ID with it. I do recommend you expedite it, or it's going to take a long time. Expediting was taking 4 months. I just had clients get theirs back in about 2.5, which I was really surprised. So maybe it's sped up a little, but I still tell them 4 months for expedited, and it's not that much more. If the child wasn't born in Texas, then I still do the Texas certificate of adoption, and I would send that and a certified copy of the adoption decree, plus whatever that birth state requires. And I always check that in advance. A lot of states have their own kind of version of a certificate of adoption. And so I'll fill that out as well. And I send in all of them. And I typically do send those in for my client. In the past, I would give my client instructions on where to send it, but I typically send them now. Okay. So let's get to questions, because I think that got me through all of that. So let me stop sharing the screen and let me pull up questions. Okay, so the first question is, does an amicus produce any sort of report, or do they just show up at the termination hearing? That depends on the amicus. A lot of amicus will do sort of a general denial. Some do a little bit more of a report. If it turns into a contested case, usually they're going to do more, but sometimes they will just show up and say that they believe this is in the best interest of the child. And how much investigating they do depends on the amicus. Again, if it's an older child, they are supposed to talk to the child age 4 over. Younger than that, sometimes they just want to see the paperwork. Sometimes they want to have a call with the adoptive parents just to see how everybody's doing. That varies. But I would say, whether they do an actual report or not just depends on the amicus. And for amicus attorneys, state statutes that you shall interview all parties. I will say that most amicus attorneys, in my experience, unless it's contested, don't interview the birth parents. That's usually not a viable option. And so that doesn't usually happen. Typically, if it's uncontested, which most of my cases are, they're going to at most talk to adoptive parents and of course child if the child is older. But it's pretty, and then if there's an agency, sometimes the agency rep, but caseworker, what have you. But they don't usually speak to, in fact, I don't think I've ever in any of my uncontested cases have them speak with birth parents. These birth parents are, birth mom is usually signing a relinquishment. And for the most part, once they've signed that relinquishment, they don't want anything to do with anybody anymore. And then birth dads, a lot of times, if they're not involved, we don't even have contact information. So hopefully that answers that question. So, okay, so I've answered those two. I see that Maricela has put in the chat the course number, so, which of course I also need to write down. And I am happy, please, if you've got other questions, please ask. We've got time. And I talked fast. I know I did. You can put them either in the question and answer or in the chat. Either way, I've got both of those pulled up to kind of keep an eye on them. Catherine, are there any questions that you see come up a lot in cases that you get asked?
No, I think you've covered it all.
I've given this talk a few times, and I update it each time, but
yeah.
Okay, how long should this take from beginning to end? That is very dependent on your facts. I will say, for me, with my cases, my typical cases are, most of my cases are agency. I represent 2 adoption agencies. Most of my terminations are agency cases. The termination case from when I get the paperwork to file till I finalize is usually about 2 to 3 months. And then adoption, again, child's supposed to be in the home for 6 months. So then, you do that, and then it's a month or 2, usually after filing, to finalize the adoption. I'm not sure how much that answers. But so typically, in a typical case, if it's uncontested, adoption, and not a department, not a CPS case, those are a little bit different. But in a typical agency or private direct placement, your termination is going to happen within 2 to 3 months after baby is born, assuming newborn, and final adoption will be in that 6 month, after the 6 months, usually in the 7th or 8th month. If you're talking about like a step parent adoption where the child's already been in the home for 6 months and you're combining everything together, those go faster because we're not waiting on paternity registry certificates. Because with the paternity registry certificate, you can't request that. Well, I request them before you hit 31 days, but it can't be run until after 31 days. And then usually, as overloaded as they are, I'm getting those back somewhere around 5 or 6 weeks post-birth, maybe 7. So I've got to wait till I get those before I terminate, and often before I even set the termination. Excuse me. So hopefully that gives you some answers on that. It really depends. If an adoption is finalized for a child who's not a U.S. citizen without going through correct procedure for immigration purposes, how do you go about reopening the adoption so as to complete the correct procedure? Yeah, I have no idea is the answer to that question. I'm not sure you can. Because once the adoption is final, the adoption is final. It's a final order. Unless you've got some reason that order is not valid, I don't think you can reopen it. So then you have to look at, are there other immigration paths that can be used? Which is why I warn everybody, if the child is not a U.S. citizen, make sure you talk to an immigration attorney first to be sure you're doing the right thing. Do I think the Indian Child Welfare Act is going to be gutted by SCOTUS? Frankly, I have no idea. I think the Indian Child Welfare Act, the purpose of the Indian Child Welfare Act is a valid purpose, and that it was to basically prevent children being removed from Indian Native American families from reservations. They were just being pulled off reservations purely because they were Native American families. And I get that, and that's not right. But the way it's worked out in practice is definitely problematic. So there's definitely some problems with the Indian Child Welfare Act, whether they gut it, whether they uphold it, whether they only cut out part of it. I really don't know what's going to happen. It's very unpredictable. I can't pretend to understand this Supreme Court. I do not know. I have my own thoughts on what should be done, but Whether that's what happens or not, I don't know, because the Supreme Court and I do not see eye to eye for sure.
All right. Thank you, Jenny, so much for your presentation. I don't see any additional questions listed. Oh,
Oh,
there
here
is one more.
Okay, here we go. Bio father's unknown, non-bio dad signed the birth certificate. Non-bio dad and girlfriend, non-bio mom live with the child, it's birth, now girlfriend wants to adopt. Agreed, but now does not. Parties no longer live together. Does bio dad need notice? So you say non-bio dad signed the birth certificate. Did he do an acknowledgement of paternity, or is he just on the birth certificate? Because that would make a difference. If the non-bio dad's done an acknowledgement of paternity, he's legally dad. And so he would have to be served for sure. Bio dad, in my mind, you still need to get rid of. If he's truly unknown, you can use paternity registry. And this is not a child under the age of 1, so you need to do due diligence and file an affidavit of due diligence that says, you know, you tried to identify, bio mom could not identify him. And so, you know, ultimately, it depends on if you're wanting to know if girlfriend can still adopt. If the child is not living with her, if the child is living with the fictional dad who's on the birth certificate, and she no longer lives there and he is opposed to it, probably not. But if the child is with her, and bio mom is still on board with her adopting, I would guess that relinquishment may name non-bio dad and girlfriend. If so, you need to do a new relinquishment for just the girlfriend. Non-bio dad being on the birth certificate, if he did any acknowledgement of paternity, you're going to have to serve him and then deal with potentially fighting him. If he didn't do an acknowledgement of paternity and the hospital put him on the birth certificate without doing that, which they're not supposed to, but sometimes they do, especially years ago, it wasn't as big a deal. You can probably do DNA testing and rebut him. But you are going to have to deal with the actual bio dad somehow. Because if you don't terminate his rights, he can come forward in the future. So you may be doing it with paternity registry if he's truly unknown, and with due diligence, mom can't remember more than, can't remember enough for you to identify and locate him, then you can use paternity registry. But you do need to do due diligence to try to identify and serve him. But whether she can still adopt if she's not living with the child, and probably not, is the short answer. And if anybody has other questions, you can always feel free to email me. I think that was on the last slide, but it's just jenny@wamakadoptions.com. And of course, DBAP has my contact info. I will warn you, I'm going on vacation next week out of the country. So thank you, Maricela, for putting that in the chat. I am going out of the country next week. So if you email me in the next 2 weeks, or actually in the next month, you may not hear back from me until December. But you can always email me or call me, and we can kind of talk a little bit more, because everything is very specific, as you probably guessed.
Awesome. Well, thank you, Jenny.